In the unfortunate event, we lose an employee. Now, who is supposed to be paid compensation as per the meaning of this act? Who is supposed to receive this compensation in the event we lose an employee because of an occupational accident? This act provides for compensation for those employees who might contract what we call occupational diseases. A good act must always start with the definitions to avoid ambiguity and to clarify issues.
Members, welcome to this WIBA 2007 webinar. For those who are new members in this association, WASPAC was established in 2019. The Workplace Safety Provision Association of Kenya is a non-profit organization dedicated to enhancing occupational safety and health standards across workplaces in Kenya. As a professional body, WASPAC fosters a collaborative network where OSH practitioners from various industries can exchange knowledge, share best practices, and advocate for safer work environments. It's an honor to introduce our esteemed speaker for today's WIBA awareness session, Mr. Seki. He's the Assistant Director at the Directorate of Occupational Safety and Health Services, DOSHS. With over 16 years of dedicated service in occupational safety and health, Mr. Leyan has been at the forefront of workplace safety regulation and policy enforcement in Kenya. His role involves ensuring compliance with the Occupational Safety and Health Act, that's OSHA 2007, and other key legislations through rigorous workplace inspections and enforcements.
Thank you, Mr. Gilbert, and our esteemed participants. As Mr. Gilbert has said, my name is Mr. Seki. I work with the DOSH, not to be confused with the DOSHI, because quite often we are confused with the DOSHI, the hardware. So DOSH is Directorate of Occupational Safety and Health Services. That's why I work as an assistant director. And my brief today is very, very simple. We are going to have an overview of what you are calling WIBA, Work Injury Benefits Act, because as a department, we draw our mandate from two acts of parliament. One is the Occupational Safety and Health Act, that is aimed at prevention of occupational accidents and diseases in the first place. And then secondly, we also implement the provisions of WIBA, Work Injury Benefits Act. So this is the act that I want us to look at, and so that we can have a look at its highlight. So in short, we call it WIBA 2007, and you understand from that slide that I'm talking about work injury benefits, but it is good for the class to note that currently we have a bill in place. We are coming up with a different act. There is a bill referred to as work injury compensation bill, whereby we are intending to introduce the so-called social insurance way of compensation. We depart from our normal compensation system, which is employer liability-based compensation system. You realize many countries worldwide are going to the social insurance way system of compensation. So we are going to come up with that act. But meanwhile, the act that is in force in terms of compensation is WIBA, Work Injury Benefits Act. It is an act of parliament. It is an act of parliament, but most importantly, what people must understand or must note is that this act provides for compensation of employees in case they sustain occupational accident or contract occupational disease while on duty. And I have to stress that, while on duty, because this act contemplates a scenario whereby an employee might be injured, an employee might sustain or might contract an occupational disease while on duty. So this act will take care of that. So it is good to note that while this act provides for compensation of these employees in case they sustain accidents or contract occupational diseases while on duty, we don't yet have a legal framework that compels an employer to pay compensation to these employees in case they are injured while off duty. It is good to stress that. So this one only provides for the framework in which an employee, the act contemplates an employee was injured or contracted an occupational disease while on duty. But having said that, I know there are some institutions, there are some institutions that take up what we call enhanced covers. Enhanced covers. Yeah, I'm sure you have heard of some people talk of WIBA Plus. WIBA Plus, whereby an employee is covered on a 24-hour basis, on a 24-hour basis. But now that one, what happens is that in that case, an employer will have to dig deeper into his pocket to pay more in terms of cover. But you are saying where we have an employee who has covered his employees against occupational accidents, against occupational diseases while on duty only under WIBA, then they have not committed any illegality. So where an employer decides to cover his employees even when they are injured or off duty, then in that case, to us, is more of an added advantage extended to the employees by the employer. So it's good to clarify that there is no act of parliament that compels an employer to pay compensation to employees in case they are injured while off duty. So it's good to highlight that. The other thing that is very, very important to note here is that this act provides for compensation for those employees who might contract what we call occupational diseases. And for occupational diseases, the threshold is a bit higher because we are saying there has to be a hazard that led to this particular disease. That component must be established by the doctor. Whoever is assessing the claimant, whoever is assessing the employee, must be able to connect between the hazard and the disease. Or in some cases, we have scenarios whereby employees are compensated because of contracting an occupational disease. Maybe they even had this underlying health condition, but this underlying health condition was aggravated by factors present at the workplace. Then you realize such employees, they have good grounds for asking for compensation, because whenever an employer is employing these employees, there is something we call pre-employment medical examination. To protect the employer against such liabilities, employers are advised to ensure employees undergo pre-employment medical examination. We need to be able to know the history of these employees and where they are coming from. Otherwise, some employees may claim that the condition, yes, they came with this particular health condition at the workplace, yes, at the time they were being hired, but they may claim at the end of the day, the condition was aggravated, the condition was worsened by factors present at the workplace. If I was hired, let's say as a cleaner, but I came in with asthma, and maybe according to the doctor's recommendation, I'm supposed to avoid dust. But when I come to the workplace, I'm exposed to dusty environments. I might argue that my condition, though it was underlying health condition, it was aggravated by this particular factor present at the workplace. So WIBA, it's good to note that WIBA, the date of commencement was 2nd June 2008, by Gazette Notice number 60 of 23rd May 2008. It actually replaced the initial act that provided for compensation of employees in case they sustain occupational accidents. We used to refer it to as a Workmen Compensation Act. So nowadays we don't talk of workmen compensation, but we talk of WIBA, Work Injury Benefits Act. And this is the act I want us to have a look at. Now, where does this law apply, or where does it apply? It is good again to note that this act is applicable to all employees, including government employees. So civil servants are included in the meaning of this, but within the meaning of this particular act. But of course, excluding armed forces, Kenya Army, Kenya Air Force, Kenya Navy, those ones have been excluded from the provisions of this particular act. And for a very simple reason to that, because remember this, the armed forces, they have a separate legal instrument that provides the manner in which such persons are going to be compensated in the event they sustain occupational injuries or even contract cases of occupational diseases. So for them, they have a separate legal instrument for that, a separate act of parliament. But remember, for all other employees, in case of occupational accidents, in case of occupational diseases, they will be compensated in accordance with the provisions of WIBA. So it's good to note that. Now, a good act must always start with the definitions to avoid ambiguity and to clarify issues. So when this act talks of compensation will include medical aid. And this is something many people forget, because as long as an employee has been injured while on duty, the medical cost is supposed to be defrayed by the employer. So the employee is not supposed to foot the bill. He's not supposed to pay from his own pocket. So the entire bill, the entire expenses are supposed to be offset by the employer, and that is part of compensation. Compensation will also include any benefit outlined in this particular act payable to the employees, or in the case of fatalities, dependents, because now in the case of fatalities, in the event we lose an employee, in the unfortunate event we lose an employee, we look for dependents. We look for dependents. So any benefit entitled to the dependents will be deemed to be compensation, and as per the meaning of this act. Now, what will be the meaning of earnings? Earnings will simply mean the amount of salary, and when I talk of salary, I mean gross, to avoid confusion. I mean gross. So I do not mean basic, I don't mean net, I mean gross salary of the employee at the time of the accident. At the time of the accident. Suppose the employee was injured in, let's say, January 2025. And this employee was earning around 100,000 shillings. So the amount of salary that will be used in compensation will be 100,000 shillings. Even if this guy was promoted in the month of February, now he's earning, from February now he's earning 200,000 shillings. So that one will be ignored. What will be taken into account is the amount of salary the employee was earning at the time of the accident, as long as it is gross. So by gross, I mean basic salary plus all regular allowances. Basic salary plus all regular allowances. Remember, that is what the law provides. That is what WIBA provides. I had mentioned the issue of some employers compensating employees even when they are off duty. But then you realize when they have such an arrangement with an insurance firm, where an employee is injured while off duty, you realize the employee is compensated under what I was calling WIBA plus. But in such arrangements, the employer does not, what is used in computing compensation is not gross salary, but basic salary. Some insurance will use basic salary, because remember I had said that this is an advantage extended to the employees from the employer. But when it comes to occupational accidents, where an employee is injured while on duty or contracts an occupational disease in the course of his work, then what will be used is the gross salary of the employee and not the basic. Injury will mean personal injury, and it will include occupational diseases. This is what I had alluded to earlier on, that most people, when we talk of compensation, most people think or attribute compensation with occupational injuries. But what they forget is the issue of occupational diseases. So what you're saying in a nutshell here is that even occupational diseases are compensatable. One can be considered for compensation should that employee contract an occupational disease as a result of workplace exposures, occupational hazards that are likely to have caused this particular disease. And remember, when the doctor is assessing the claimant, for the occupational disease, the doctor doesn't have to prove beyond what lawyers call in criminal cases, beyond reasonable doubt. What happens is that the doctor has only to prove beyond a balance of probability, just slightly over 50%. Is there a chance that because of this exposure X, this exposure X could have led to this particular occupational disease? Why? Is there that chance? Where that chance is slightly over 50%, that one will be enough for the doctor to conclude that the illness is an occupational disease, and therefore that employee will be considered for compensation. Where the Act talks of director will mean Director of Occupational Safety and Health Services. So not to be confused with any other designation. So it will mean Director DOSHS, in other words, Directorate of Occupational Safety and Health Services. So it's good for the law to give those definition of terms. And the other one is employer. When the law says the employer will compensate employees, who is this employer? What is the meaning of the employer as per the Act? An employer, as per the meaning of the Act, will be deemed to be any person who employs an employee and includes the legal personal representative of a deceased employer, even if the actual employer died a long time ago, but we have a legal representative of the deceased employer. Such a person will be deemed to be the employer, or any other person who is controlling the business on behalf of the actual employer. It is also possible, and from my own experience, I visited so many institutions, so many organizations, whereby you realize the actual employer is not even based in Kenya. the actual employer is based in, let's say, in another country. But whoever is in charge, whoever is controlling the business of that employer at that particular time, could be the HR, could be the finance manager, could be whoever, such a person, the topmost person at that particular time, will be deemed to be the employer. And therefore, such a person will be expected to comply with the provisions of this particular act. The government will be treated as an employer. I said, in case we have a civil servant, or in case we have a police officer involved in an occupational accident or contracts an occupational disease, such persons are going to be compensated by the government. So the government has not been left out. So the government will be deemed to be one of the employers. And then trustees of a club or an association of persons will also be deemed to be employers. For instance, if we have an employee employed by, let's say, Modaiga Golf Club or Nyali Golf Club, or maybe, let's say, Sigona Golf Club. So such an employee employed by an association of persons, such association of persons will be deemed to be the employer of this employee. So trustees of any club will be taken to mean the employers of this particular employee. So that will be the meaning of the word employer as per the act. But then again, what about the employee? When we talk of employee, who is an employee? Because I've come across some arguments, some people arguing that no, this person was only hired for some few hours, this person was only engaged for a few days or a few weeks. In any case, there is no contract between my employer, my client, and this employee. So such a person will not be deemed to be an employee. So who is an employee? The law has to be very, very clear what will be the meaning of the term employee. A person will be considered to be an employee if this person is employed for wages or a salary and a contract of service. Remember, this contract of service may take different dimensions. One may be hired on maybe permanent terms, permanent and pensionable terms, contract terms, or even casual terms. It doesn't matter. So such a person will be deemed to be an employee. And we are also including an apprentice, persons on attachment, persons on internship, okay? Maybe they are learning a particular trade elsewhere in a particular college, in a particular university, but they have been engaged by the firm. They have been engaged by the company to work for them. So such persons will be deemed to be employees. I know there is this common argument that is normally fronted around that in case these people sustain occupational accidents, then this will be taken care of by their own insurance, because to many organizations, before you hire them, they have to come with their own insurance cover. But I've also seen it being argued, especially in legal circles, that the person who was benefiting from the services of this employee is the employer. And therefore, the employer should be able to take care of the compensation of these persons. In any case, the act, the law includes them, identifies them as employees, I've also seen some employers arguing they're also benefiting from me as an employer because they are learning on the job, they are learning tricks of the job. So it is more of a symbiotic kind of a relationship. But then again, at that juncture, now we leave it to the lawyers to argue it out, depending on how they interpret that particular section. But of most important to note here is that persons on attachment or even internship are considered as employees of the organization. And this section 1, remember, applies irrespective. It doesn't matter for those people who have been engaged on contract or where there is a contract between the employer and the employee. It doesn't matter whether the contract is expressed or implied. Because for most of us, where we work in many organizations, we have an express contract that is in writing. It is a formal contract. It is in writing between the employer and the employee. It is straightforward. But this law also recognizes what we call oral contracts. Oral contracts, where a supervisor, for instance, engages some employees, decides to pick some few individuals outside the company. And Amewambia, you come here, try to assist us in offloading some items to the warehouse. So such persons, in case they are involved in an accident, they will be deemed to have been hired by the employer, because the supervisor in this case will be deemed to be an agent of the employer. So where those people have been engaged orally, the law considers them as employees, as long as the due procedure has been followed. But then again, this law also recognizes implied contracts. Implied contracts will mean this is a situation whereby the employer will not engage the employee either orally or formally, but the actions of the employer may be construed to mean that he accepted the services of these employees. For instance, when I used to work in Mombasa, for those guys who are coming from Mombasa, there was a time I used to work there, and when we used to go out for inspection, especially in a place called Shimanzi, there are several warehouses in that Shimanzi. What I used to observe is that you realize a truck will come loaded with let's say fertilizer or even some other grains, and then it will come park outside the warehouse. And then you realize there were some individuals who are idling outside the warehouse. They jump onto the truck and they start offloading and packing the said fertilizer in the warehouse. At all this time, the owner of the cargo is silent. He doesn't. He has not told them to start offloading, or he has not stopped them from offloading. So the law may construe that to mean that the owner of the cargo, or the employee in this case, accepted their services, because this person never intervened, either by way of maybe asking them not to offload, okay, in that case. So in that case, that is a contract that can be implied, and that one is recognized by this particular law. But then again, for somebody to be considered as an employee, this is a person who must be paid either in cash or any other recognized legal tender, either M-Pesa, RTGS, EFT, any recognized legal tender. You cannot claim to be an employee. For instance, those people who volunteer their services to an employer without any form of payment. As per the meaning of this section, it will be very difficult for them to prove that they were employees of the said organization, because maybe at that particular time they were not getting anything. But some people may argue that maybe they were getting some stipends, and stipends is a form of cash, or they are paid by cash or M-Pesa or any other recognized legal tender, and so therefore in that case they should be considered as employees. But in a situation whereby we have that voluntary work, and these people are not being paid either in cash or any other recognized legal tender, then this section does not deem such persons to be employees. Okay, does not deem such persons to be employees. So that is the meaning of the word employees, to avoid confusion. Because ordinarily what happens is that with the many employers in some organizations, they argue that yes, we agree the person was injured, but the person was not my employee at the time of the accident, or maybe the employee was only hired for some few hours, he was only hired for some few days, some few weeks. So that argument will not hold water under the meaning of this section. Now, I had alluded to earlier on that when it comes to compensation, employees involved in occupational accidents, the so-called non-fatal occupational accidents, where somebody was injured, but fortunately the person did not lose his life, such persons will be compensated directly. But now complication sets in here, where we talk of fatalities. What happens in the case of fatalities? In the unfortunate event, we lose an employee. Now, who is supposed to be paid compensation as per the meaning of this act? Who is supposed to receive this compensation in the event we lose an employee because of an occupational accident? And remember, I'm talking about occupational accident or occupational disease, because we have cases, from my experience, we have cases of some employees, let's say an employee collapsing at the workplace. Collapsing at the workplace, and maybe by bad luck, the employee passes away. Now, at that juncture, do we conclude that the person who collapsed at the workplace died because of an occupational accident by the mere fact that this person was on duty at the time of the accident? That is far from the truth, because in such scenario, because that is a question that I can be, maybe somebody will have wanted to ask at the end of this presentation. What happens is that in such an eventuality, at that juncture, we don't conclude whether the accident is occupational or not. We wait for something called a post-mortem report. A post-mortem report will be able to reveal the cause of death. So from the cause of death, now we can be able to relate whether it is related to the workplace or not. If it is related, then the dependents of the deceased are going to be compensated. But if no relation, then you realize in that case, the compensation will not apply there, unless now the company or the organization has the so-called WIBA plus, the comprehensive cover, 24-hour cover. In that case, then there will be no problem to that effect. Now, problem will only be where an employer has only taken WIBA cover only to cover the employee while on duty. Now, in case of fatalities, in case we lose an employee, who will be considered as a dependent? Remember, for the avoidance of doubt, a dependent is any person who was depending on the employee for the necessities of life, clothing, shelter, food, all the necessities of life. Such a person will be deemed to be a dependent. Now, the first person to be considered as a dependent will be the wife of the deceased. Remember, the wife or wives of the deceased. The deceased could have left behind one widow, two widow, three widow, four widows. Some religions allow up to four, someone to marry up to 4 wives. So the deceased could have left up to 4 wives. So all of them will be deemed to be dependent. So widow or widows or widower or widower. Take note that the word widower is not in plural. It is in singular form. So the law does not contemplate. The law does not imagine. The law does not envisage a scenario whereby we lose a female employee and then more than one husband turn up claiming compensation or asking for compensation. So the law only contemplates that only one husband will turn up to claim for compensation. So that is widow, widows, or widower, the husband. So the husband of a deceased female employee can actually be considered for compensation. But before I move from that bulletin, let me clarify this. I have 2 issues to or even 3 issues to clarify. One is that where a deceased left behind 2, 3, or even 4 widows, more than one widow, the widows will share out the compensation equally as per the meaning of Section 6 of WIBA. So they will be sharing the compensation equally. So the issue of who was married first, who was married last will not arise. That is clarification number 1. Clarification number 2 is where a widow, and get it this clearly, where a widow remarries, of course after the death of the husband, where a widow remarries even before compensation is paid out, the fact that the widow remarried does not in any way disentitle her from compensation. She will still receive her rightful compensation. Compensation itamfuata kule yuko. Hata kama alikuja akaolewa Kisumu, tutamfuata huko alipwe compensation. So the fact that she remarried, that one on that account does not disentitle that lady from her rightful compensation. That is clarification number 2. Clarification number 3 is that religious and customary beliefs do not override. They do not in any way override the provisions of this act. Okay, a good example will be the case of some communities. Take the example of some communities whereby inheritance, whereby if I lose my brother in some communities, some cultures, I am allowed to inherit the wife of my brother. In case I lose my brother, I am allowed to inherit his wife. Now, the fact that I inherited my brother, my wife, my brother's wife, that act alone does not entitle me now, the new husband, to be entitled to compensation. I still miss out on compensation. So compensation will still go to the rightful dependent. So those are the 3 clarifications I wanted to make there before I move from that bulletin. Now, another person to be considered for compensation will be your child. I'm a child of the deceased. A child of the deceased person will be considered for compensation. A stepchild, that's another good example of what I said earlier on about religious and customary beliefs, because there was somewhere I was doing this presentation and some people are telling me that in our culture, stepchildren are not recognized. But I was too quick to point out that religious and customary beliefs have said they are inferior to the provisions of this act. So where stepchildren are involved, they are also considered for compensation. Or even adopted child. Maybe the deceased may have adopted the brother's child, the sister's child, or any other child for that matter, even if they are not related by blood. Such an adopted child can be considered for compensation. We also including posthumous child, a posthumous child. Now the big question is, who is a posthumous child? Now, in the event the husband died before his child is born. But remember, mtoto ni wa the husband, aliacha mama na mimba. Aliacha mama na mimba. But now the husband died before the child was born. Huyu mtoto akizaliwa baadaye, we call him or her a posthumous child. A posthumous child. So that such a child is also considered for compensation. In other words, this is of course a child born after the death of the father. But this law excludes children who are married or self-supporting. Those ones are excluded by this law. The law assumes married children, self-supporting children are independent. They are independent. So they are excluded from compensation under this act. But from my experience, I've also seen married children and self-supporting children having been paid compensation, but under what grounds? The main ground is whereby you cannot be able to identify any other dependent. The only dependent that can be identified is a child who is already married or a child who is self-supporting. So in such an event, such an eventuality, you realize they are paying compensation anyway, because no any other dependent could be identified. But where they are around, they are married, they are self-supporting, priority is given to other deserving cases in terms of compensation. And then we have the parent, we have the step parent, we have the foster parent. Whoever adopted the employee will be considered for compensation. But this adoption must have been before the accident, before the fatal accident. It must have been before, not after. Not after. And then adoption must have followed the legal process. It must be within the law, within what the law stipulates. And then a child of an employee not contemplated by bulletin 2. Ikibainika waziwazi kwamba the deceased sired a child, maybe out of wedlock, and this is his or her biological child, then in this case, such a child can be considered for compensation. It can be considered for compensation. Your brothers can be considered for compensation. Your sisters, your half brothers, half sisters of the deceased, grandparents of the deceased, grandchild of the deceased can actually be considered for compensation. Or any other person now who was dependent on the deceased for all the necessities of life, even if they are not related by blood or marriage. But we have evidence that this person was wholly dependent on the deceased. So such a person can actually be considered for compensation. Now, the big question is, now what happens in case no dependent can be traced? What happens in an event where, or in an eventuality where no dependents can be traced? We lose an employee, but we are unable to trace any dependent. Now, in such a scenario, according to the Act, according to the WIBA, WIBA gives the government powers, that is through the Directorate of Occupational Safety, those are DOSHS, through the Director DOSHS, to invest these funds that were supposed to be paid as compensation in a money generating scheme. Let's say treasury bills, treasury bonds, or something of that nature, MMF, to invest these funds in the interest of the dependents whenever they are going to show up. Whenever they are going to show up. Although I've seen that one rarely happening. So what has been happening is that these funds. Hello. Gilbert.
Yes, let me mute them. Let me mute all of them. I don't know why people are misbehaving.
Kindly mute them because
let's
I can hear some background noise.
I've muted them. Okay,
good. Yeah, so I was trying to explain that in an event whereby we cannot be able to trace any dependent, the government has powers to invest such funds for the benefit of the dependents whenever they are going to show up. so that whenever they show up, at least the amount of money will have multiplied. But nowadays, remember, we also have UFA. The government has set up an agency we call UFA, Unclaimed Financial Assets Authority. So I normally see some of these funds being channeled towards UFA for either investment or maybe try to trace the possible, probable dependents. So that is a list of dependents as outlined under Section 6. Remember, this one is outlined under Section 6 of WIBA. So Section 6 of WIBA is very, very, very clear. Now, Section 7 of WIBA compels an employer to obtain and maintain an insurance policy. Remember, each employer must obtain and maintain an insurance policy. So what that means in a nutshell is that every employer by law is required to take up a WIBA cover to cover his employees against occupational accidents and cases of occupational diseases. So by law, they have to do that. But remember, this one was one of the most contentious sections. I remember this section being challenged by the LSK, Law Society of Kenya, in the High Court, because they were aggrieved by the statement in red, whereby this section was saying it was compelling an employer to obtain and maintain an insurance policy approved by the minister. So what brought about contention is those words, approved by the minister. By minister, I mean a minister at the time being responsible for labor matters, Minister for Labor and Social Security. That was meaning, the meaning of that particular section was that the Minister of Labor may wake up one morning and decide to approve maybe 2 or 3 insurance agencies for purposes of WIBA. So all employers must take up an insurance cover with those agencies approved by the minister. But LSK raised an issue with this. They raised an issue with this. Of course, the government was trying to defend itself, because what the government was saying is that the reason why they came up with that provision is to protect employers against rogue insurance companies, because it was coming at the advent whereby some insurance firms, you could submit a claim to some insurance firms and they do not honor the claim. They do not pay out the claim. So the government was trying to protect employers against rogue insurance companies. But then again, the court was very quick to remind the government that how they cannot front that narrative, because already we have IRA, what we call Insurance Regulatory Authority, which is a government agency that is supposed to regulate the insurance sector. So we have the IRA that is supposed to play that role. So that role cannot be played by the government. So the section was, those words approved by the minister, of course, were declared null and void by the High Court in High Court Petition number 185 of 2008. And this judgment was upheld by the Court of Appeal in Civil Appeal number 133 of 2011, because Attorney General was not contented with the decision made by the High Court. Remember, the case was before High Court Judge Justice Jackton Ojwang around 2008, 2009 there. But remember, the then High Court Judge Jackton Ojwang went all the way to Supreme Court. I think now he has retired, but he's the one who had the case at the High Court before the case proceeded to the Court of Appeal, whereby it was heard by a 3-judge bench, Philip Waki, Mahandia, and Ouko. And what happens in this case is that they upheld the decision of the High Court. So what are the implications? Implications now are employers now are at liberty to take up an insurance cover with any insurance firm of their choice, as long as the insurance firm is approved, is recognized by IRA, Insurance Regulatory Authority. They are free to take up an insurance cover with such an insurance agency. So we look at right to compensation. Who is supposed to be compensated? Bulletin 1 and 2, we were very clear that any person who sustain an occupational accident will be considered for compensation. Any person who contracts an occupational disease will be considered for compensation. I think that one we are very, very clear from the slide 1. But it is also good to note that an employee can actually be considered for compensation if at the time of the accident, whatever that employee was doing can be said to be in the best interest of the employer. Okay, for instance, if you visit an organization, let's say fire has occurred in a particular organization, and we have somebody, this fire has broke out in let's say procurement office. Procurement office is on fire, and then we have the receptionist. So the receptionist decides, as he may decide, to go to the procurement section and put out the fire. But unfortunately, she sustained some burns. He or she sustained some burns. So according to this act, such a receptionist can be considered for compensation, even if she is not involved in procurement, she was not hired as a procurement officer, she doesn't work in procurement department, but at the time of the accident, whatever she was doing can be said to be in the best interest of the employer, because she was interested in taking care of employer's property to ensure the employer's properties is not damaged by the fire. That is another ground. Another ground for one can be considered for compensation is commuting. But for commuting, you must be commuting to work or from work in a vehicle provided by the company. In a vehicle provided by the company. Not owned by the employer. Provided. I've said provided. So where an employer decides to hire a staff bus from, let's say, Glory Car Hire, to be transporting his employees to and from work, such a vehicle will be deemed to have been provided by the employer. So the moment you are inside that vehicle and it is involved in an accident, you are deemed to have sustained an occupational accident, and therefore you are supposed to be considered for compensation, or such an employee is supposed to be considered for compensation. But the case is different for those employees who go to work or from work in a PSV, public service vehicle. Remember, the law is very silent on that. What happens to an employee who goes to work in a matatu, or from work in a matatu, commutes to work and from work in a matatu? Unless now in that case, that issue will be taken care of by a different act of parliament, because remember, even the matatus, even the PSVs are supposed to be insured. So whoever was inside the vehicle, whoever was inside that matatu, is supposed to be compensated by the owner of the matatu, the owner of the vehicle. So the law, what the law says here is that there is no way the liability in a matatu, that the matatu is the one that occasioned the occupational accident, but the matatu is not owned by the employer. So there is no way that liability can be transferred from the owner of the matatu to the employer. Okay, and even if the employer has taken up a 24-hour cover, the employer decides to compensate the employee, even if he was not the owner of the matatu, then in that case the employer can actually sue the owner of the matatu to seek reimbursement of any funds or any amount of money paid to the employee as a result of the occupational, or as a result of the accident, a traffic accident in this case, in this manner. So it's good to clarify that. The law is also very silent on somebody going to work on foot, very, very silent on that, or even going to work in a bicycle, or from work in a bicycle, or even in some animals, a punda, donkey. The law is very silent, or very, very silent on that. Although this is something that was taken up during the review of this WIBA. Remember, I had started by saying that we have a bill already in place, the Work Injury Compensation Bill. So I believe that one has taken care of this, because there was a lacuna here. There was some kind of a lacuna here in this particular law, whereby it was not clear what happens to such employees. But the law is clear in a situation whereby the vehicle has been provided by the employer. Another section that was contested by the LSK at the High Court, Law Society of Kenya, was Section 10.4, that was providing for the purposes of this act, an occupational accident or disease resulting in serious disablement or death of an employee is deemed to have arisen out of and in the course of employment, if the accident was due to an act done by the employee for the purpose or in the interest or in connection with the business of the employer, despite the fact that the employee was at the time of the accident acting in contravention of any law or any instructions by or on behalf of his employer, or without any instructions from his employer. So what this section was saying in a nutshell is that, take an example of two employees. take an example of two employees. One employee is working with machine A. One employee works with machine A. The other one works with machine B. The other one is supposed to work with operate machine B only. The first one operates machine A. Now you realize the person operating machine A, out of his own curiosity, out of his own volition, decides, without lawful instructions from his employer, decides to operate machine B. But remember, his assigned machinery is machine A, not B. But out of his own volition, out of curiosity, he decides to operate machine B. So in that event, he sustained a serious accident or even dies. In a situation whereby he sustained a serious accident, this law, or this section was saying that such an employee will be considered for compensation, irrespective of whether he had lawful instructions from the employer or not. It doesn't matter. It doesn't matter. Or where that employee dies, then the dependents will be considered for compensation. Remember, this employee acted out of his own volition. There were no lawful instructions from the employer. So that one becomes what happened on that account alone. This is what made LSK to rush to court. They rushed to court to challenge the validity of that particular section. And in the High Court petition number 185 of 2008, they argued before High Court Judge Justice Jackton Ojwang, they argued that this section 10.4 cannot be allowed to start. Because in any case, why are we punishing the employer? Remember, this person was acting in contravention of an employer's lawful instructions. Then why is it we want to punish that employer? So they were arguing that this section takes the constitutional right of any form of defense on the part of the employer that may be had. So in that case, High Court Judge Justice Jackton Ojwang actually agreed with LSK. He agreed with LSK and actually declared the section to be null and void. That is section 10.4 of WIBA, because the judge argued that this section creates liability on the part of the employer without fault. We underline without fault. Even when the employee is clearly demonstrated to be at fault. Why do we want to punish the employer? So in that case, the High Court judge agreed with LSK and the section was declared null and void. Of course, the case, as I said earlier, went all the way up to Supreme Court, up to the Court of Appeal in Civil Appeal number 133 of 2011 before Waki, Mahande, and Oko. And to some extent, the Court of Appeal appeared to have agreed with Justice Ojwang's ruling on that matter. In fact, they went ahead and they were saying that, they declared that actually 10.4 cannot be allowed to stand because in addition, it actually offends the principle of extrupi causa non uritur action. What that simply means is that if at the time of the accident, the employee was engaging in a criminal activity, illegal activity, or immoral activity, there is no way such an employee can be allowed to benefit from his own criminality, from his own illegal activity, from his own immoral activity. A good example, if at the time of the accident, the employee was injured while trying to steal company property. Yes, he was lawfully on duty. We do not refute that. He was lawfully on duty. But at the time of the accident, the employee was trying to cut away employer's property. So in the process, the employee was involved in an accident. So the employee was committing a criminal act. So there is no way he can be expected to claim for compensation. Okay, or even illegal activity where an employee decides to go contrary to lawful employer's instructions, and then he sustained an occupational accident. There is no way he can turn around and ask for compensation. Or even immoral activities. If we have an employee who decides, the employee is on duty, but the employee, maybe during night shift, the employee decides to rape, to commit a rape, to commit rape. So in this case, and this employee is involved in an accident in the process, there is no way such an employee can be expected to claim compensation under the meaning of that particular act, because it will be argued that at the time of the accident, the employee was engaging in an immoral activity as at the time of the accident. So Court of Appeal to some extent agreed with Justice Ojuang. To put this into perspective, I decided to use this case study. Recently, I think, is it a week or 2 weeks ago, there was a court ruling there was a Court of Appeal ruling. The court was sitting in Nakuru, and it involved. I decided to come up with this case study because it is a classical example of what we are talking about. A classical example. This Court of Appeal, there was a decision that was made by the Court of Appeal sitting in Nakuru, and the case involved one Macharia. Macharia was a passenger. Macharia, remember, was a passenger, and Charles Amariba versus Charles Amariba and BM Security Limited. Charles Amariba was an employee of BM Security Limited, and he had been hired as a driver. So what are the facts of the case? The Court of Appeal recently ruled, that is Justice Paul Gashoka, Mohammed Wasame, and John Mativo, recently ruled that employers are not automatically liable for an employee's wrongful act if the act was outside the scope of employment and for personal gain. Because what was happening is that on January 9th, 2012, Macharia was waiting to board a matatu to Nakuru. Remember, Macharia is not an employee of BM Security Limited. Only Charles Amariba is an employee of BM Security Limited. Even if he was an employee of BM Security Limited, I don't think company laws and procedures and regulations allowed him to be carried, to be chauffeured by Charles Amariba. So the guy decides to stop Amariba because Amariba was on his way to Nakuru. Amariba decides to onboard him, invited Macharia to board the vehicle. Macharia accepted the invitation, but on condition he buys tea to the driver as a form of payment, as a form of thanks for having been allowed to board the vehicle. So the vehicle was then involved in a road traffic accident where it veered off the road and overturned. After this, Macharia sustained a fracture to his right scapula and a sprain to his right shoulder. Later, Macharia sued Amariba. Amariba, remember, was the driver employed by BM Security and BM Security for negligence, alleging the accident occurred within the scope of the driver's employment. High Court ruled that BM Security was vicariously liable for the accident and should thus compensate Macharia. For starters, vicarious liability means this is a situation whereby an employer is blamed for the acts of his or her servants, for the wrongful acts of his or her servants. You realize that the blame is extended to the employer. We call it vicarious liability. So the High Court was of the opinion that BM Security should actually compensate Macharia, because they held BM Security Limited vicariously liable for the accident. In other words, BM Security Limited is being blamed for the misdeeds of their servant, who is one Charles Amariba. But of course, dissatisfied, the company, that is BM Security, decided to file an appeal at the Court of Appeal, arguing that the driver was not acting within his employment scope, and therefore the company claimed its vehicles were clearly branded with the company logo, which prohibited unauthorized passengers, a fact Macharia knew but chose to ignore. So it was very clear for Macharia that the vehicle was clearly branded, that maybe the driver is not allowed to carry unauthorized persons inside the vehicle, but it appears Macharia ignored that particular warning. So according to the Court of Appeal, and this will have a far-reaching effect on other cases. According to the Court of Appeal decided to do away with the High Court judgment, and therefore ruled that the employer BM Security Limited is not to blame is not to blame for the accident, but one Charles Amariba, who was the driver, is personally liable for the accident and is therefore the one expected. The driver is the one expected now to compensate Masharia and not BM Security Limited. So I saw it wise to share with you that recent judgment that was made in Nakuru, because it is clearly illustrating our earlier point there. Remember, after the Court of Appeal, of course, the case went all the way to Supreme Court. Up to Supreme Court, the Law Society of Kenya, of course, they were not contented with the judgment made by the Court of Appeal. Remember, civil case number 133 of 2011, they were not contented, so they decided to sue again to appeal the case at the Supreme Court. So the case was heard by a 3-judge bench, Lenaola, Wanjala, Njoki, Ndongo. But in summary, in terms of summarizing their findings, this is what they stated: that for the avoidance of doubt, the determination in civil appeal number 133 of 2011, Waki, Mahande, and Ouko, is hereby upheld. So all the judgments that were made by the Court of Appeal in that civil appeal case, that judgment is still standing because it was upheld. The ruling was upheld by the Supreme Court in petition number 4 of 2019. So remember Section 10(4). Remember, Section 10(4) is now those people who are going to engage themselves in acts of illegality, criminality, or even immorality. They risk losing out on compensation. Now, circumstances, the director. Remember, when I talk of director, I mean Director DOSHS. Director may decline to grant an award. What are the circumstances the director? Remember, as per WIBA, it is the Director DOSHS that is supposed to ensure that the claimant have received their rightful compensation. It is the director to ensure that. But under what circumstances can director decline to grant an award? Decline to say that this claim is compensatable? Under what circumstances? Number one, where an employee decides to give false information to an employer about sustaining an occupational accident, and it is proved, investigations have proved that actually this employee lied that he was injured at the workplace, but in reality, actually, this person was injured maybe at home, or maybe he was injured while off duty, not while on duty, but decides to lie for purposes of seeking compensation. So that one, the director may decline to grant. Another ground is failure by an employee to submit himself or herself to medical assessment. Remember, no one can be compensated in Kenya without a medical assessment, because there are two factors that determines how much somebody will be paid in terms of compensation. Factor number one is the salary of the employee, which is gross. The second factor is the assessment from the doctor. So where the employee decides not to avail himself or herself for this assessment, that employee risks losing out on compensation. There was a time I used to work in Narok, and we had an interesting case whereby somebody was injured. There's a company known as Mara Farming in Narok. There was somebody who was injured there. The company decided tried all it could to have the employee assessed medically for purposes of compensation, but the employee flatly refused to be assessed because he was claiming he belongs to a particular sect, and this sect does not recognize modern medicine. They believe in traditional medicine. So you realize such an employee risk missing out on compensation. So it's good to note those 2 points there. This is another also very, very interesting slide, or another interesting section, that is section 11, about claim processing procedures. Claim processing procedure, because section 16, it is very clear. Okay, what has been happening is that some employees, they sustain accidents. Once they sustain occupational accidents, they rush to court. They rush to court without giving a chance for the WIBA processes to be completed. But recently, the court was emphatic, whereby the court decided that before somebody comes to court because of an occupational accident, such person can only come to court by way of appeal, but such person must exhaust all the avenues listed in WIBA, Work Injury Benefits Act, as per section 16. which says no action shall be by an employee or any dependent of an employee for the recovery of damages in respect of any occupational accident or disease resulting in the disablement or death of such of employee against such employee's employer, and no liability for compensation on the part of such employer shall arise, save under the provisions of this act. Save under the provisions of this act. So what that essentially means is that before somebody rushes to court, that person must give the procedures outlined in this act a chance. Okay, so those processes must be completed to its final conclusion before now somebody can rush to court, but by way of appeal. So even now what is happening is that some claimants, without maybe they don't have this knowledge, they don't know about this provision. When they are rushing to the lawyers currently, what is happening is that the lawyers are actually redirecting them back to DOSHS for the processes to be completed. And if they are not satisfied with the processes, the law allows them to go to court. Okay, that act of going to court has not been taken, that right has not been taken away from them. But what this section is saying, let them exhaust the procedures set out in the act before somebody rushes to court. I think the court realized at the end of the day, they realized they are dealing with so many claims. So many claims involving occupational accidents. So some courts were getting overwhelmed by the number of these cases. And then it was realized all these cases are coming to court even without due process having been followed. The DOSH processes have not been exhausted. So I think the court was very clear on this. To support this issue, the court cited some past decisions, because whenever a court is making a ruling, it must be guided by past decisions, what they call in legal circles as judicial precedent. But remember, a higher court is not bound by the decisions of a lower court. Let's say the High Court can only be bound by the decisions of the Court of Appeal. The Court of Appeal can only be bound by the decisions of the Supreme Court and not the High Court. So remember, a court can only be bound in its decision by decisions made by a superior, by a higher court, as the case may be. So in the case of the Speaker of the National Assembly versus Karume of 1992, Kenya Law Records, it was ruled that where there is a clear procedure for the redress of any particular grievance prescribed by the Constitution or an act of Parliament, that procedure should strictly be adhered to. Because already we have an act of Parliament, that is WIBA, that clearly outlines the procedure that is supposed to be followed when an employee is seeking compensation. So they are not allowed to rush to court at the first instance without exhausting these procedures set out in WIBA. Another case was Samindong Waitito versus IEBC, Independent Electoral Boundaries Commission, and 3 others of 2019. The Supreme Court was candid, where the Constitution or any other established, or any other law, like in our case WIBA, established an organ, in our case DOSH, with a clear mandate for the resolution as a given class of disputes. No other body can lawfully usurp such powers, nor can it append such organs from the pedestrian execution of its mandate. So in a nutshell, DOSH must be allowed to complete its processes before somebody can rush to court by way of an appeal. So section 16 is very, very clear on that. Now, touching on medical examination, I think when I started this presentation, I was very clear that medical expenses are defrayed by the employer. The employee is not supposed to foot the medical expenses. Now, what about medical assessment? Where an employee is required by the employer to avail himself or herself before a certain doctor for medical assessment. That employee, number one, must avail himself or herself, and then the cost of that assessment will be borne by the employer. Will be met by the employer, the cost of assessment. But the law allows the employee, at his own expense to have a medical practitioner of his choice. We have cases whereby some employees maybe they doubt the expertise of the doctor fronted by the employer. So some cases you have some employees maybe even doubting the reports, but the law allows them to have their own medical practitioner of their choice present at an examination or at an assessment that is to be done by a designated health practitioner, by a doctor. But in this case, they can only do that at their own expense. They'll be now required to pay this doctor now, their own doctor. But for the one that has been availed by the employer, the employees are not supposed to pay anything. So assessment, in other words, is free of charge to the employee. So how do we compute compensation? How do we compute compensation? Now, compensation, I started by saying that it's dependent on two factors. One, salary of the employee. Number two, what else? Assessment done by the medical doctor. Now, there are two forms. So when you are trying to compute compensation, when the doctor is assessing a claimant, when a doctor is assessing the employee, the doctor may decide to award what we call permanent incapacity, or what is referred to as temporary incapacity. Now, what is the difference? Permanent incapacity means because of the accident, an employee lost a part of his body, or a part of his body lost functionality. Maybe a chemical entered the employee's eyes. The employee cannot be able to see. So the employee's eyes lost functionality. That is permanent incapacity. Or death. Death will be deemed to be permanent incapacity. In fact, death is 100%. For death in Akwaga automatic is 100%. Temporary, the employee did not lose any part of his body, but he was injured nevertheless. Maybe he sustained a cut on his hand. And then after 2 weeks, after 3 weeks, the cut healed. But the hand is still functional. The hand is okay. The employee never lost the hand. So we call it temporary incapacity, and is expressed in the form of days, the days out of work. How many days was he not able to work? Okay. So how do we compute this compensation? So you take, remember, permanent incapacity is expressed by the medical doctor in the form of a percentage. In the form of a percentage. For fatal cases, the percentage is automatic, is 100%. But where an employee loses his hand, let's say right hand, the doctor may award, let's say 40% or even 60%. So you take the 60%, you multiply by the salary of the employee. Remember how we define salary? Salary is gross salary. Basic salary plus all regular allowances. That is how we defined it. Remember. And then times 96 times 96 months. Some people may ask, why 96? Remember, this is number one. First reason. This is what is legislated in WIBA. It should be pointed out that this is what is actually contained in WIBA, because WIBA provides for an employee to be compensated for up to 96 months. In fact, it talks of 8 years, equivalent to 96 months. Under workmen compensation, it used to be 60 months, but it was enhanced under WIBA all the way to 96. That is reason number one. Reason number two, remember, where do we get these formulas from? We try to borrow best practices from ILO, International Labour Organization. Remember, Kenya is a member of ILO. So we borrow what we call best labor practices from other countries. How do other countries compute their compensation? And then we try to incorporate them in our statutes. And then reason number three, remember, these formulas, they come after years and years of negotiations between the stakeholders. By stakeholders, I mean government of Kenya. I also mean COTU in the case of workers. I mean FKE in the case of employers, Federation of Kenya Employers. So stakeholders, they have to agree. Temporary capacity, I've said, is number of days out of work multiplied by the salary, basic plus regular allowances, divided by 30 days. 30 days for employees on permanent terms. Employees on permanent terms. Employees on casual terms, you divide by 26. Because remember, I may not be an expert of the Employment Act, but I know there is somewhere that it provides that an employee is entitled to at least one rest day per week. But I need to be corrected in case that is not the correct position. I need to be corrected. So so it comes to around four rest days in a week, in a month. So in that case, for casual employees, you have to divide by 26. But for permanent staff, whether it is weekend, whether it's Saturday, Sunday, doesn't matter. They are still on the payroll. So you divide by 30 days. Another clarification before I continue. Temporary incapacity, remember, the law assumes the employee lost an income during the entire period of temporary incapacity. The employee was not earning an income. Now, in the event the employer decides to pay the employee a salary during the period of incapacity, what you are supposed to do, you are supposed to less whatever the employer paid during the period of temporary incapacity from the total compensation payable under temporary incapacity. In other words, the employee is not supposed to receive twice. He's not supposed to get the salary on one hand, and then on the other hand, he's also getting compensation under temporary incapacity for loss of income. That amounts to double payment. And that is why you realize for permanent staff, most of them, they miss out on TI, temporary incapacity, because in any case, they are paid a salary, whichever the case. Even if they are recuperating at home for 30 days, they are on permanent terms. They will still get their salary. So it's good to clarify that to avoid confusion. Remember, amount of compensation is not taxable. It is tax-free. It is tax-free. No one is allowed to tax this compensation, because when an employee is compensated, we say the employee has not gained. It is not like a benefit, even though our law talks of benefits. But if you look at it critically, there is no way an employee can be said to have gained. We are actually reinstating the position they were before the access. So compensation is tax-free. Another point to note as we wind up because of time, remember, claim for compensation must be lodged with the employer within 12 months. Within 12 months. What that means is that where an employee is involved in an accident, that employee has up to 12 months to inform the employer. So the employer then informs DOSHS. DOSHS now process the claim. And once the DOSHS process the claim, and then the claim is submitted back to the employer is supposed to settle that claim within 90 days. Within 90 days, having received WIBA 4. There is something we call WIBA 4. These calculations, the one we were talking about, are actually done on a form we call WIBA 4. So the WIBA 4 is then transmitted to the employer. Employer anaipeleka kwa insurance. The insurance then is supposed to settle the claim within 90 days. So the issue of I was injured somewhere, I have stayed for 2 years, 3 years, 4 years without compensation, then that is an issue of the past and should not arise, because compensation should be settled within 90 days, assuming all other factors are constant. No appeal has been received. We are assuming during this period no appeal has been, because where an appeal has been received, then the period expected to be longer than 90 days. Now, a right to benefits shall lapse if the accident is not reported to the employer within 12 months. So employees, this is for employees to note. Where an employee has been injured, the employee must report the accident to the employer within 12 months. Within 12 months. Although, if you read that section critically, there is another subsection that says failure of an employee to report an occupational accident to the employer will not be a bar to compensation if it is proved that the employer knew about that accident, even from other sources, not from the employee now, even from the media, social media, whichever media, from other sources, the employer knew about the accident. So it will not be a bar to compensation. That is ground number one. Ground number two, it will not be a bar to compensation where an occupational accident is reported after 12 months, where the employee was unable to report because of factors beyond his capability. For instance, I remember there was an occupational accident somewhere, and somebody was injured. Somebody was taken to Kenyatta National Hospital. The guy was in a coma. The guy was in a coma for more than 12 months. So there is no way such a person could have been expected to report within within 12 months. So there are those peculiar, isolated reasons that will still make an employee to be compensated, even if the accident is reported to the employer after 12 months. Medical aid, I think you are very clear. No need of belaboring this body, because I said all medical expenses are defrayed by the employer. They are paid by the employer, including first aid facilities. I think this one I was very clear. I was very clear on that. Let's look at appeals before we wind up. Objections and appeals. Objections and appeals. Remember, under Section 51, it allows any objector. I am using the word objector. Objector to mean the objector can be an employee, objector can be an insurance agency on behalf of the employer, an objector can be in the employer himself. Any objector aggrieved by the decision of the director may appeal within 60 days. 60 days from the date on WIBA 4. WIBA 4, remember, is the form that we do calculation on. The calculation is done on WIBA 4, and that date indicated on WIBA 4 is deemed to indicate the decision, the date on which the decision of the director was made. So from that date indicated on WIBA 4, then you start counting. You have any objector will have up to 60 days from the date indicated on WIBA 4 to file an appeal, to DOSHS. But objection must be in writing. Whoever is appealing must do so in writing. There is a form that is used for appealing. We call it DOSHS WIBA 12. So whoever is appealing must fill that form and must attach any supporting documents, maybe to make his case stronger, to make his case very strong. So supporting documents can be attached. After this, the director must give a formal response to the objector within 14 days. Not more than 14 days should pass before the director gives his or her decision. So the director may give a response varying or upholding his decisions and indicating the reasons. So the director DOSHS is bound by law. Where he decides to vary his earlier decision, he must give a reason. Where he decides to uphold his earlier decision, he must give a reason. He's bound by law under Section 51. Okay, so there must be a reason why the decision was varied or was upheld. Now, in case the objector is still dissatisfied by the director's reply, then this is the only window now the objector is allowed to go to court now. Yeah? This is the entry point of going to court now. Yeah? Remember, I said processes at DOSHS have to be completed first. So an objector is allowed by law to institute an appeal at the Employment and Labor Relations Court within 30 days. Within 30 days, an employee may lodge, or an objector may lodge an appeal with the Employment and Labor Relations Court. Previously, it used to be referred to as industrial court, but nowadays it is Employment and Labor Relations Court. Before I move from this slide, it is good to clarify that, remember, Employment and Labor Relations Court enjoys the same status with the High Court, and also with the other court in Environment and Land Court. Those two courts are at the level of the High Court. So where somebody lodges an appeal at the Employment, Labor and Labor Relations Court, kama tu amelodge kwa High Court. So in case that person is not satisfied with the decision of the Employment, Labor and Labor Relations Court, then that person can move to Court of Appeal. That person can move to a Court of Appeal. So this is a court that is headed by a judge. It is headed by a judge. So it's good to note that. Now, what are some of the challenges we encounter during processing of these claims? Do we have challenges? Because it's a question that maybe somebody will have wanted to ask me, but I can pick a few challenges, and we can discuss these few challenges before we close. So these are some of the challenges we encounter during processing of these claims. One of them is conflicting hours by doctors. You realize an employee will be injured. An employee will be required to present himself before Dr. A for primary assessment, medical assessment. So Dr. A decides to award the employee 70% permanent incapacity. Okay, the claim is then taken to DOSH. DOSH does its processing. The claim is submitted to the insurance, and then the insurance object. They object to that percentage, claiming the percentage is on the higher side. So the employee is then required to submit himself before a Dr. B, acting for the insurance, for a second medical assessment. So Dr. B decides to award the employee, let's say, 5%. Remember, the initial doctor was 70%. The secondary doctor awards 5%. So we have conflicting awards. But in such an eventuality, what happens? In such case, then where we have conflicting awards, then the employee will be required to submit himself for a final assessment to be carried out at DOSH. At DOSH, we have something we call WIEC, or rather Work Injury Evaluation Clinic. Work Injury Evaluation Clinic. We call it WIEC. In our terminology, you call it WIEC. But that is Work Injury Evaluation Clinic. It sits on, is it Mondays and Thursdays? I'll find out. But it is 2 days. It sits on that board, that panel of doctors. Minimum, wanakuwaga watatu, 3. So that panel of doctors, they normally sit on 2 days in a week, Mondays and Thursdays. So the employee will be expected to be assessed, to undergo final assessment by that panel, panel of doctors. Minimum required is 3. So the employee will be required to avail himself before that panel. So the decision that will be made by the panel will be the one now that will be used in now completing a fresh WIBA form, assuming no appeals. Because remember, even at this stage, the employee can still appeal, can still present himself before that medical panel and then appeal to the director DOSH, even go to court. Okay, so but where there is no appeal, a fresh DOSH WIBA form will be filled, being guided by the assessment coming from the WIEC, Work Injury Evaluation Clinic, domiciled at DOSH headquarters. Another challenge is tracing dependents. How do we trace some dependents? How do we trace some dependents? By the way, when we were discussing Section 6, the one that is listing the dependents, when we were discussing Section 6, we never asked ourselves, well, now what happens in a situation whereby the employee the deceased employee was a foreigner? How do you trace the dependents of this person? Maybe the employee was a Chinese national working with a contractor XYZ, maybe doing some works, some road works, maybe along Thika Road. So how do you trace the dependents of this Chinese national? Okay, that one to us is a big challenge, although luckily we try to use the embassies. The embassies come in handy. They try to assist us in locating the dependents of such expatriates. Now, another challenge is incomplete DOSH 1. You have some employers, maybe out of ignorance, or maybe they are not aware of how that DOSH 1 is supposed to be completed. Some people will fill DOSH 1, but they will give us incomplete information. Somebody will fill employers' particulars, employees' particulars, but then if you look at the salary section is nil. The salary is not indicated. The salary of the employee is not indicated, or some other crucial information is missing on DOSH 1. Remember, DOSH 1 is the form that is used to report an occupational accident. Remember, DOSH 1 actually is the one that kickstarts the compensation process. Nobody in Kenya really can be compensated without DOSH 1, as long as it is an occupational accident. As long as it is an occupational accident, that form must be completed by the employer and then must be submitted to DOSH. Luckily nowadays, submission is online. They don't have to do it manually like before. It used to be a little bit stressful, whereby they used to do it manually. Maybe you go to a DOSH office, you find it is closed, you go back with your form. But nowadays, things are easier. They simply upload the form on the system, and the officer who is in the office will be able to have a look at that form and be able to complete the process. So it's good to note that. Remember, DOSH 1 is divided into 3 parts: Part 1, 2, and 3. Part 1, the employer fills the employer's particulars, employees' particulars, but Part 2 is for doctor's assessment. Remember, the assessment I was talking about will be entered by the doctor on Part 2. Part 3 is for official use. That one now, the DOSH officer will fill Part 3. So that one will not be filled by the employer. Now, the other challenge is delayed healing. We have some complaints from some employees. They will say they were assessed by medical doctors. Now, they had not completely healed. So the doctor was not able to give a proper assessment, So those are some of the complaints we get. So what they ask for additional assessment with the hope of getting additional compensation. In the hope of getting additional compensation. So that one is a big challenge also on our side. The other one is fraud. We have some employees, some very clever employees who alter or even who bring fictitious medical bills, because we said medical expenses are catered for by the employer, where an employee paid for the medical expenses, then the employee can be reimbursed as long as some letter receipts. But when they are challenged to bring those receipts, some of them they bring fictitious receipts with the help of making a quick buck there. The other point of fraud is alteration of percentages. Okay, this one is we have tried our level best to circumvent this via the new online system, but you realize during the manual system, what used to happen is that an employee will be injured, he will be assessed by a medical doctor, so the employee will be given DOSH 1 to take it to the nearest DOSH office. So the employee will look at part 2, the one that is filled by the doctor. Maybe the doctor has assessed the employee and decides to award this person 6%. So the doctor is supposed to write the same in figures and in words, 6%, and in figures also, very clear. But you find some employees altering these percentages. So instead of 6%, an employee will add TY at the end of the word 6 to read 60%. In the place of between 6 and the percentage, the employee adds a 0. So you realize now the percentage in words corresponds with the percentage in figures, but it is fictitious. It's not the actual percentage that was awarded by the medical doctor. What the employee is aiming for enhanced compensation through alteration of percentages. The other challenge is inadequate compensation. We have so many complaints of employees complaining that, hey, when I was injured, I lost too much blood because of that injury. And in your claim compensation process, in how you are computing your compensation, that fact of me losing a lot of blood during that injury has not been taken care of by this formula. What is happening here? So we have such complaints, but you normally tell them, us as a department, we implement what is in the law. So we basically implement the formula provided for in WIBA. Some cases we can encounter violent or even impatient claimants. To many claimants, they think that compensation is just supposed to take 1 or 2 or even 3 days. They forget that it is a process. It is a process. So most of them, they tend to be very, very impatient. And that is why they rush to lawyers, thinking that lawyers will give them a quick remedy, only for the lawyers to turn them to refer them back to DOSH for processes to be completed as per the meaning of Section 16 of the Work Injury Benefits Act. So as I wind up, let me wind up with two case studies, just 2 case studies, so that we can be able to align our presentations with these 2 case studies. One was involving, these are court cases. Court case number 1 was involving David Kibe versus an employer referred to as AB Limited. David Kibe, this guy was employed as a cleaner by the company, and the person was injured when he slipped while cleaning the premises of the company. The guy sustained an injury on his backbone, and High Court Judge, Employment and Labor Relations Court, the then High Court Judge James Rika, decided to award the employee 1.8 million. And this one was the verdict of the court. The court held that the court is not satisfied that the company provided a safe working environment to one Mr. Kibe. It was foreseeable that a cleaner working with soap and water could actually slip and fall. The accident happened as a result of the respondent's negligence and holds the respondent 100% liable for the for the for the occurrence. That is case study 1. Case study 2, court case number 2, Nixon Mudoka versus Jasho Farm. Nixon Mudoka was an employee employed by Jasho Farm, and this guy sustained an electric shock. What he was doing, he was trying to connect some irrigation pipes at the farm of Jasho Farm, but in the process, the employee sustained electric shocks. The then High Court judge, Lady Justice Pauline Yamoya, ruled that Mr. Mudoka was supposed to be paid 2.4 million, with a large chunk of that money being general damages for pain and suffering. Okay, so that was the second court case. So of course I have more court cases, but in the interest of time, we cannot be able to go to each and every case. But I decided just to pick those two to bring you up to speed of our deliberations, of our discussions, what we have been discussing all through in this particular WIBA presentations. So I think on that note, I think I intend to stop there in the interest of time, and maybe allow questions from the floor. So, Mr. Gilbert, I return back the program to you to moderate the question and answer session.
Thank you. Thank you, Mr. Seki. Thank you very much. You have answered so many questions we normally receive in our inboxes as WhatsApp for us to respond. You have already answered a lot of the questions.